determination of whether someone's a member of Tender or Wagwa, that's a separate question. But for injunctive and declaratory relief that does not seek release from confinement, Supreme Court has said time and again, that's not habeas.
Your Honor, I disagree. And had they brought this case in district court in Texas, they could have raised it as both APA and habeas. They instead elected to choose a different court. And that meant that that came with all the jurisdictional limitations of that particular court.
It's a venue issue for habeas, not jurisdictional. That doesn't affect the jurisdiction of the district court. That's a venue issue, whether you're suing the custodian.
Your Honor, it's not subject matter jurisdiction, but it does go to the authority of the court. And in the Rumsfeld versus Padilla, the Supreme Court did say it was jurisdictional, not in the subject matter jurisdiction, but it's not just a mere venue rule. It cuts to the core authority of the court to grant habeas relief.
Well, as long as it can be served with the process is the test, right? As long as the defendants can be served with process, then we've got jurisdiction. It's just a venue argument. And an important one, I'm not diminishing that at all. Courts frequently enforce the venue requirement that you sue the right custodian, and that custodian is by definition in the district where the person's detained.
Your Honor, we certainly agree that it's case dispositive. I think it's not, venue may undersell how important it is. Supreme Court has characterized it as jurisdictional in the sense that it goes outright to the authority of the court and not merely a sort of, steering things to where they might be convenient to be heard. It's something more fundamental than that. But in any event, that probably doesn't matter because I think we're agreeing that if venue is improper or for habeas, like the court is just simply out of authority to do anything.
Okay. All right, we'll give you a couple of minutes to reply.
Thank you, Your Honors.
Mr. Miller.
Good afternoon, Your Honors. Lee Galern from the ACLU for Plaintiffs. Time permitting, I want to address why this court, the courts absolutely have jurisdiction to review whether the statutory predicates to the Alien Enemies Act have been met and why they haven't been met here. But I want to put that aside for the moment and sort of jump into the conversation you've been having with the government. First, I just want to put one thing to bed. The district court has not said anything yet about whether he intends to try and bring people back who are already sent to El Salvador. The district court is very concerned, understandably, that his order was violated, but he is trying to get to the bottom of those facts. He has not made a determination of whether his order was violated, much less what he would do as a remedy, whether he would try and order the individuals back. So I don't think that issue is before this court. And so I think that's a red herring. The second thing is that I think the government now, and we in the government have sort of joined issue. At a minimum, it seems like the government is grudgingly admitting that after Ludecky and footnote 17 in particular, that there must be ability to contest whether you fall within the act. And so now I think it's a question of how that's going to go about
happening. Within the proclamation, not the act.
I'm sorry?
Within the proclamation.
Well, yes, within the proclamation. And so the district court has said very clearly he wants to figure out how that would work. He has asked both of us, neither us or the government had a clear answer for him at the moment when he asked it, the hearing. He intends to get to the bottom of it. But I think what it means is that even if this TRO was appealable, and we don't think it is, but even if it was, I think it's the easy ground to affirm the TRO is that there was no process. And I want to be very clear about 2 points. One is that the process, to the extent the government says you can have process, that's illusory. People were designated TDA without any advance notice, rushed to Plains. We will put into the district court the piece of paper that individuals are getting that specifically says you are not entitled to review. So there is a lot of factual development left to do in the district court. Judge Boasberg is working extremely hard and extremely quickly, but I think this court would want that factual record. And I think that's one of the reasons the TRO is not appealable. This is not, yes.
Could you have done everything in a Texas district court that you did in this district court?
Perhaps, Your Honor, but I don't think it was necessary. There's absolutely no question now that the law is that this kind of challenge where you're not seeking release doesn't have to be brought in habeas. It can be brought by APA. It could be brought in habeas, but it doesn't need to be.
Well, so I want to get to that in a minute. But I think the common ground that you've just sort of asserted and that the government, you said, kind of has begrudgingly given, it's really significant common ground that I think has been lost in some of the briefing and some of the transcripts. You could have filed the exact same complaint that you filed here in Texas District Court. The government is not contesting that each plaintiff could have gone before an Article 3 judge and said, I am not a member of Trinidad Aragua, so I'm not covered by the proclamation, so I can't be removed. And could have done that. I think you would both agree that the plaintiff could have done that with a habeas petition. I know you push back and say it doesn't have to be a habeas petition, but I think you would agree that everything I just said is true and that it could have been done through a habeas petition. Is that right?
Well, Your Honor, yeah, I mean, I don't think it's insignificant that it didn't have to be by habeas and that we have to, what plaintiffs, we can choose our venue, but I want to address your question specifically. We could have filed a class, perhaps, a class habeas, if that's what you mean, but we certainly weren't looking just to get our 5 individuals from being sent to a Salvadoran prison.
Right.
So this would have had to be a class. If the government is suggesting that we could have gone in there for every individual, absolutely not. We did not know who's been designated. This has all been done in secret. The president signed it.
I think you're going beyond what my question was.
Okay, I
and I'm not sure
apologize.
the government would agree that you can certify a class in habeas.
Well,
I'm not sure I
exactly.
would agree with that either. It's that more of an open question that we would need to look into. But on Saturday, early afternoon, you asked the district court to enjoin the removal of the 5 named plaintiffs. The district court did. A Southern District of Texas court could have done that as well, right?
So, I just want to factually,
Okay.
when we filed it at 2 in.the morning, whether it's Friday night or Saturday morning, the district court in the early morning enjoined the 5 named plaintiffs. The class papers had already been filed with the complaint at 2 in.the morning, both complaint for declaratory injunctive relief and habeas, with class papers seeking a TRO for the class. The district court then held a hearing at 5 p.m. to decide whether his TRO was going to apply to the whole class. Absent a class TRO, we would have had far more people sitting in a Salvadoran prison.
I get that, but my question is not about what the district. My question for now is not about what the district court did. It's just about whether everything the district court did, which you just described, and I was off by a few hours, but it was Saturday.
Right.
It was a long Saturday. Everything that happened that the district court did, a Southern District of Texas district court could have done.
Assuming they would do it as a class, yes.
So I think that nicely tees up where the real dispute is, because you're not saying you couldn't have done all this in Texas. And the government is saying, A, this has to be habeas, and habeas has to be in the district where the detainee is detained, and that would be Texas. So I know you disagree with both of those things, but I think the government, I think there's some common ground there.
There's common ground now that there has to be process, although I still see the government accepting it grudgingly, because this whole pre-deprivation thing, we were talking about people being sent to El Salvador, one of the worst prisons in the world, incommunicado. They're essentially being disappeared. The president of El Salvador has now said maybe they're going to spend the rest of their lives there. The government has provided zero ability to bring habeases. It would have had to have been done by a class, and to the extent the government's saying going forward, we'll give you process, I have not heard one word about them giving us
At this
advance
point-
notice.
At this point, everyone who's detained can bring, would you say that at this point, everyone who's detained can bring a habeas petition?
Because of the TRO by Judge Boasberg only. And that is even assuming, and I don't think this is true, that everyone has been clearly designated, that we know exactly who the government thinks falls under the proclamation. And therefore, if they didn't file a habeas right away, they could be put on a plane. And so I certainly don't think this is the way it would go about with individual habeases, you know, and
If the TRO were lifted, there wouldn't be a meaningful way to bring habeas.
I think the government was going to put people back on a plane immediately, just as they did. The whole thing has played out in secret. The president is supposed to make a public proclamation. He signed it on March 14th. It wasn't published till the afternoon of March 15th. People were already being lined up to be brought to planes. So I think we're dealing with something that is illusory, and that's even if we accept that habeas can be brought. But I
mean, we know it can be brought because you brought it. You filed a habeas petition.
it could be brought by habeas, but it doesn't have to be. And I think
So
we are,
Let's go to that, whether it has to be.
right.
And I think perhaps reasonable people can disagree about this. I think it's hard to get around LeBeau v. Christopher. The district court addressed it today.
I'm sorry, hard to,
LeBeau, I may be pronouncing it
yeah.
wrong.
So that,
Can I just read?
yeah,
from
sure.
the-
I'm sorry, Your Honor.
Says, of course, the plaintiff's focus is not explicitly on their present custody. That's very similar to this case where you're saying, you know, we're not asking to be let out of detention. We're just saying don't transfer us to one of these other countries. Says, of course, the plaintiff's focus is not explicitly on their present custody. They claim the nature of the relief requested is different here since they have not formally sought a release from custody as in the habeas action. But, and the court goes on, we have rejected precisely such efforts to manipulate the preclusive effect of habeas jurisdiction. So I think that's a tough precedent for you where LeBeau was, as I understand it, was about to be extradited to Canada, didn't want to be extradited to Canada, could have filed in Illinois where he was detained, actually did file a habeas petition there, filed in DDC, and our court said, no, you can't bring this suit in DDC. You have to bring a habeas suit in Illinois to challenge not your detention, your transfer to Canada.
Yeah, Your Honor, a few things about LeBeau, then I want to sort of broaden it. LeBeau is an extradition case. The extradition has for 225 years had its own case law, but I think the key in LeBeau that the court understood was that they were in fact seeking release through the other habeas. And so it seemed a little bit like they were trying to circumvent the habeas. I think that's why it's different. But the case law is voluminous that you don't have to bring a habeas unless it's a core habeas challenge to release. And I just want to touch on Thursingham for a second, that Judge Millett brought up. Thursingham, the government walked into the Supreme Court and said, the only time habeas can be used is when you're seeking release from detention. You can't challenge your removal. That was ultimately what the Supreme Court accepted. That was the holding. That's on top of case after case after case saying, if you're not seeking release, and I want to be 100% clear, no class member is seeking release. Judge Boasberg was absolutely clear that his order will not stop anybody from being prosecuted, anybody from being detained, allowing anybody to be released, allowing anybody.
There no, and I don't know the answer to this question. I tried to ask the government.
Yeah.
I think maybe they didn't know yet. You may not know either, and suspect you haven't talked individually with every one of your class members. But do you know if anyone is currently being detained under the Alien Enemies Act proclamation and not being detained under any other legal ground?
I don't know the answer to that. I suspect that most people, maybe all of them, are being detained on the immigration laws because they were in proceedings. I mean, the government is using the act to try and short circuit the immigration proceedings. And so I think what they have done is pull people out of proceedings and put them on the plane to El Salvador. So
your original complaint mentioned apprehension and removal, and you wanted to enjoin both. I understand the district court did not take you up, did not accept your invitation to enjoin apprehension, but that does suggest that you were worried there would be some class members currently at large in the country who might be apprehended under this AEA authority.
So, Your Honor, I think to the extent that that language is in there, it may be inartful, but we're 100% clear with Judge Boasberg, and he has been 100% clear. We are absolutely not trying to get anybody out of detention, stop anybody's removal, stop anybody's prosecution. And I think that goes to the larger point. This is a very specific statute, a wartime statute dealing with a very specific problem. It does not bar any other authority for prosecuting or removing these individuals, much less have to do with anything about stopping ships in China.
Can I ask you about Munaf v. Guerin? Because I do understand how you can read it to help the government here, and you can read it to help you here. I think the government is saying the first thing the Supreme Court held there was there is habeas jurisdiction. This is someone who wasn't objecting to being held, but was objecting to being transferred from U.S. custody in Iraq to the Iraqi government in Iraq, and said, don't transfer to the Iraqi government. And the first thing the Supreme Court held was that there is habeas jurisdiction for that because he was an American citizen. And then said, in your habeas cause of action, you lose on the merits, right? Because we're going to respect the Iraq's kind of what they said is Iraq's exclusive jurisdiction to punish offenses against the laws committed within its borders. So we have habeas jurisdiction, and habeas is your cause of action. But with that cause of action, you lose on the merits because of Iraq's exclusive jurisdiction to punish offenses against its laws committed within its borders. And if that's how it's read, it seems like Munaf is a pretty good precedent for the government saying, look, if you want to challenge your transfer from U.S. custody to another nation's custody, your cause of action is habeas.
I think two things about that, Your Honor. One is Munaf said you could do habeas. It didn't say you must habeas. And I think that's the difference in these core habeas cases. Whether you could bring it in habeas, you often can bring it in habeas, but then whether you must bring it in habeas. So we understand the Chief Justice to be saying in that case, I think it was fairly clear, the last thing you want is simple release.
Right.
And so I think that's why Munaf doesn't answer the question. And Thursingham, of course, is the most recent precedent from the Supreme Court.
On the not having to bring it as habeas, the district court understands your cause of action to be an APA cause of action. I think the government says this is a presidential proclamation. It's different than an agency proclamation. I think last time I was on a panel and you were the attorney, it was an agency proclamation. And you can bring it, we see every day in this court challenges to agency order under the APA. But if there's a challenge to a presidential order, the APA is not typically the vehicle for that. And Franklin v. Massachusetts says, at least as a general matter, it can't be. I think what you'll say is, at least on the individualized determinations of whether the class members are part of Tren de Aragua, you're going to use the APA to challenge decisions that are being made by lower level officials. To me, that, if true, just indicates that there's not the type of commonality for a class that you need in order to certify a class.
Right, Your Honor, so a couple of things. One is that we cited multiple cases that say even where there's a presidential proclamation, you can challenge its implementation by the agency. But to your common question, our common questions are obviously first, whether the AEA can be used at all against a non-foreign government. But the second question is, are they entitled to process? So at some point, if there's individual determinations about whether you fall within the proclamation, those obviously will be all common. But the initial question that we're fighting with the government about, and they're still, I think, grudgingly only conceding it, is whether they're entitled to some process. They clearly have not been given process, but for this action, I don't think the government would be conceding what it had to concede.
What's the status of the habeas petitions in Texas, the ones that have been filed and that are ongoing?
Yeah, that's a good question, Your Honor. We've been trying at council table to find out a little bit about where they are. I think they're generally on hold. And those individuals, there were a few habeas petitions, very few people who happen to sort of guess that maybe their person is going to be designated. But for the vast majority of people, they haven't been designated. I wanted to also clear up one point of confusion. The government keeps reading from the transcript at page 41 that the judge's initial TRO, the judge has obviously made clear this morning what his TRO is principally based on. But the judge's hearing transcript on Saturday night was very clear that he was also talking about process. And that's at pages 29 and 30, starting at line 25, Your Honor, where he was very specifically talking about process, and footnote 17 in Ludecky that said you have to be able to contest whether you fall within the proclamation. So
Sorry, finish.
yeah, no, I'm sorry.
I want to ask about, I guess this goes to some degree, I think it goes to the irreparable harm the government asserts.
Right.
And to some degree to maybe larger issues. And so the question I'm going to ask you is going to sound like I have some skepticism about what the district court did on Saturday. I want to preface that by saying, like, we've had a week to look at this issue and it's been hard. And the district court only had a day.
Right.
You know, about a decade ago, one member of this court, long before I was on it, talked about district judges having to deal with Guantanamo issues. So they were difficult and intricate and complicated and novel. And he said, even when this court might disagree with the district court decision, that disagreement is with respect for the dedicated work of the district court in these matters. That said, I'm wondering if you can point me to a district court TRO or injunction that survived appeal, that stopped an ongoing, partially overseas national security operation in the way that this, at the time at least, did order planes to take foreigners from international waters to the United States.
Your Honor, so to start with, the order about him bringing people back, potentially bringing people back, is not before you. And I think there's a lot of factual development. And I don't know how much this court is aware, but there have been emergency proceedings almost every day. And I think the district court has not been pleased with how the lack of forthcoming attempt.
I just
you know,
that though.
yeah. And so, but that,
there's
yeah.
There's this declaration by, it says that he's been at the State Department since 1971.
Kozak.
54 years ago. My math is right. That's quite a lot of experience in the State Department. Now he's a career State Department official, head of the Western Hemisphere's Affairs Bureau. And he says that this TRO is, quote, harming the foreign policy of the United States. It comes after, quote, intensive and delicate negotiations with El Salvador and the Maduro regime, risk the possibility that those governments will change their minds. It gives them leverage for renegotiation. And he warns, quote, these harms could arise even in the short term. So, I mean, those concerns are ongoing. I understand that there are no longer planes in the air that are being ordered to return to the United States with foreigners that the executive branch doesn't think should be in the United States. I guess just maybe from a 10,000-foot perspective, I thought about when Justice Douglas enjoined the bombing of Cambodia, but it didn't go very well. The Supreme Court reversed him in about 6 hours. I found a couple other injunctions that are somewhat analogous, but they didn't survive appellate review either. Can you, standing here, give us an example of a district court injunction that enjoined a national security operation partially overseas that survived appellate review?
Well, Your Honor, I want to push back on the overseas part because I don't think the order to return the planes is before you. So what we're talking about is not sending people, and that is
Foreign policy
straight removal. But
negotiations with
okay,
the Maduro regime.
so let me address that. So
Well,
yeah, no,
I will not stop you from having time to address that, but can you just tell me what's an example of a district court enjoining a national security operation with foreign relations implications? I think we could at least agree on that.
So I think for one thing, I would cite Boumediene with the Supreme Court saying there has to be habeas. I mean, the government could not have argued more strenuously that the court should not interfere and say that they're entitled to habeas while they're at Guantanamo. But to your point about the national security, I want to return to something that Judge Millett said. The government cannot take the position that it's an interference by this court on national security grounds to give people process. The Supreme Court was 100% clear in Ludecky in footnote 17 in multiple cases saying process. So for the government to say, you're interfering by giving what Justice Frankfurter said in Ludecky was necessary as a matter of the act, and I don't even think he needed due process. He was ruling as a matter of the act. You have to be able to contest. The implications of not giving people a chance to contest it are extraordinary. I mean, every religious and ethnic group in this country has at some point been tagged as associated with a criminal organization. If people can just be picked up and sent.
Mr. Galern, I mean, I just have to stop you. You're not getting an argument from this bench
Okay.
so far today against the idea that every single member of this class
Okay.
can have an individualized habeas determination in front of an Article III judge to say, I'm innocent. And I think I take your point about Boumediene and your point about Ludecky, but I think it's hard to answer some of our questions without mentioning cases that are habeas cases. Boumediene was habeas, Ludecky was habeas. And so it seems like in order to answer one question in a way that is kind of satisfactory for your position.
Well, that's because they were asking for release.
But you are asking to stop a transfer, and that is something that habeas has been used for repeatedly.
It could be used, but it doesn't have to be used. And we, of course, but I think, Your Honor, I want to return maybe to the very beginning of this appeal. We don't think there's jurisdiction over a TRO. I mean, you just had the decision in Dellinger. That's a very, very rare thing for this court to find that a TRO is appealable. And there are two preconditions. One is that it's a mandatory injunction not preserving the status quo. Judge Boasberg was explicit that he's simply preserving the status quo. And the other thing is that the harm can't be undone. You cited Mr. Kozak's affidavit. That's the last sentence in a 2-page affidavit, which says there would be harm, but then he switches to could when he's talking about the short term. And all we're saying is that,
we as judges don't know everything that the State Department knows.
well, I think there's a reason why he switched from would to could in that sentence when he was talking about the short term. We're here asking that Judge Boasberg be allowed to do his work. And I think counsel for the government repeatedly answered questions to this panel by saying, I don't really know, there's not a factual record yet.
How do you just, on the question of whether this TRO is the type of normal TRO that can't be appealed or is the type of unusual TRO that can be appealed? We have this Adams v. Vance case from 1978. It says that you can appeal that TRO, and it called it an intrusion on executive discretion in the field of foreign policy. I mean, I know you maybe don't think that's what's going on here, but the government argues that that's what's going on here. So it seems like if you lose on the sort of merits of this argument, you should also lose on the is it appealable part of the argument.
Well, I think, Your Honor, that Adams was very different because it was a mandatory injunction telling the Secretary of State what to do. And this is very different. It's preserving the status quo. And there was also a fuller affidavit.
I understand the planes are not in the air now, but it was not preserving the status quo when the planes were ordered to be turned around.
Well, Your Honor, again, I'm not sure I have much more to say on that other than that is about whether a district court's order, a federal judge's order was violated, but he still has not made any determination. So it is not before you. In saying that keep these people on the ground, don't let them be removed under the Alien Enemies Act. This is an unprecedented move to use the Alien Enemies Act for only the 4th time in our country's history without a declared war. He's saying preserve the status quo until we can find all the facts. And I think what we're going to show in the district court is that many, if not most of the people removed had no connection to the gang, that the gang does not actually have a formal structure with members. We're going to put in evidence about what happens in a Salvadoran prison, that you could remain there for the rest of your life. We're going to put in evidence, hopefully, about what the timing was and who signed it. President Trump has introduced confusion about now whether he actually even signed the proclamation. So all we're saying is that Judge Boasberg is working very hard.
I mean,
Sorry.
no doubt. Sorry, you can finish that sentence.
No, I was just saying
he's working very hard, and that he has had to move very fast.
And I think we're going to move on a preliminary injunction very quickly. And I think for this court to sanction anything about what the government's doing, or even to say Judge Boasberg shouldn't have time to figure out what the process is so it's not an illusory ability to contest, without a factual record, I think that is probably short-circuiting the way the system should work. I mean, we're really talking about something extraordinary to name a gang rather than a foreign country. This was a wartime measure meant for war.
Let me just, in terms of irreparable harm to your clients in terms of El Salvador prison that you just mentioned, all the things that you've just
Mhm.
that you've just articulated. What's your response to the government's argument? You can maybe do all that, but you just got to do it in the right court. And the right court is in Texas, not here.
Yeah, Your Honor, I just want to make, I want to answer that, but I just want to make one other point. The government seemed to be suggesting that this was about pre-deprivation, as if there wouldn't be harm if they were in El Salvador in prison for a few days. But I don't hear the government saying, if you win that habeas, we'll bring you back from El Salvador in prison. So it's a little bit of, the question, I'm not sure I have more to say other than there is case after case, starting with the Supreme Court's case decision in Prizer in the 1970s through Thurasingham, saying you do not need to bring a case in habeas unless it's a core habeas, meaning you are seeking release from detention. And Thurasingham was as strong as you can be on that. That, it was a case that I argued, and it was unfortunate because we were asking the habeas be expanded, but that's where it's ended up. And that just builds on multiple cases from this court and from the district court saying there's a difference between whether you have to bring it in habeas and whether you could bring it in habeas. And so, but at a minimum, I think Judge Boasberg is going to try and figure that out and decide what process, because if the TRO is lifted now, as Judge Millett pointed out, our people are on a plane. They're just on a plane. And so I think Judge Boasberg has done a good job of saying, here's an easy ground to say, if assuming it's appealable, here's an easy ground to affirm the TRO.
Why wouldn't 5 minutes after the TRO is lifted, why wouldn't your next move be to file a habeas petition in Raymondville, Texas, where they're being detained?
A class action? Well, we don't know that.
The 5 named plaintiffs.
Well, I mean, to begin with, we're looking not to just have our 5 named plaintiffs not end up in a Salvador
prison. If you're right that a habeas class action is possible, you could file a habeas class action.
Well, I want to also make this point. The government is doing everything in secret. We have no idea if everyone's in Texas. So all of a sudden we see a plane leaving from Arizona and they say, well, you filed it in Texas. So I don't know if the government's asking us to file in every single district in the country or whether they're going to specifically tell us where people are being designated and give us time to do it.
I mean, maybe, but the strangest place of all to file would be in Washington, D.C., where there's likely not a single person detained under the AEA.
Well, the people are being, I mean, just as a factual point, but I don't want to dwell on it. People are being moved from every part of the country. So we actually don't know whether people were originally in DC because the government's not saying it. We know people.
Detention center in Washington.
Well, we know there could be in the surrounding areas, but I think that the proclamation is coming out of here. The agency heads who are enforcing it are out of here. And I think this is a fairly standard place to bring it. But unless, we can't even begin to figure out where to file all our habeases, even assuming a class action habeas, if the government's not going to tell us who has been designated in every district they're in.
Do you know where the 5 named plaintiffs are held?
The 5 named plaintiffs are in Texas now. They came from all over.
I would think they could file a habeas petition in Texas, and you could try to use those 5 named plaintiffs to represent a nationwide class. And I'm not saying you would get the class certified or you wouldn't get the class certified, but at least the court making that decision would be the right venue for the 5 named class members.
Yeah, I mean, Your Honor, to begin with, once we're doing that, why Texas versus DC? Just because the 5 named plaintiffs happen to be there at the moment. I mean,
Rumsfeld v. Padilla could have argued this. I mean, why? What was the?
Well, because those are,
could have argued
yeah,
this.
I mean, those are.
You're supposed to file habeas where you're detained.
Well, only if it's a core habeas. I mean, the immediate custodian rule applies only where you're seeking release because you want to be where the district director is. Your Honor, I may have sort of said what I can say about the core habeas. I think there's just too much law now to backtrack on that.
As a habeas class action?
The Supreme Court has ruled on the merits on habeas class actions. So, but it's an open question. And so if we went there and only had habeas and they said, for reasons unrelated to this case, we're not going to allow a class action, then I think our people would be back on a plane in El Salvador.
How many people do you represent right now?
Your Honor, I wish I knew. The government will not tell us who they
represent more than the 5 named.
Oh, absolutely. It's a class. And
every one of those is your client.
yes, absolutely, Your Honor.
And so every one of those would need to have you file a habeas action if you can find where they are and what district to do it in.
Absolutely. And then going forward, we'd have to know, the government has said they're going to continue designating people. And, just to the point of, I get that we're now at a point where the government or this panel is not saying it's in some venue you can contest. But it's really an extraordinary thing that's happening because people were rushed out, as Judge Boasberg said, and story after story is now coming out that people had nothing to do with the gang. And so I think we're looking at people now who may be in a Salvadoran prison the rest of their lives. And I think that's really the problem. And incommunicado, families can't reach them. There's no way to reach them, and the government wants to continue doing it. And I don't, when Judge Boasberg said, well, how would the process work? And, will there be pre-deprivation? The government didn't answer. And I hear the government also bringing up pre-deprivation again. So I just want to be clear that right now, as this is moving so quickly, I think Judge Boasberg has said, at a minimum, under Ludecky, the implementation of this proclamation cannot stand. And for that reason alone, I think the TRO has to be affirmed. We're going to move on a preliminary injunction. It will be back here, no doubt, from either
What are you
side
moving
on
on
a
your
full
PI?
record. I'm sorry?
What are you moving on the PI?
We're going to move in a couple of days, Your Honor, and we're trying to just gather as much facts as we can. Family members are seeing the videos of the harsh treatment men received when they got off the plane. They're alerting us. They're alerting us because they think the men have disappeared from U.S. detention facilities and they think they may be in El Salvador. We're also going to put in expert declarations about how the TDA gang works and that there's actually no formal membership. So figuring out who's part of TDA is very, very difficult, and a number of other factual developments. I would think this court, if it's going to rule on such an extraordinary issue, only the fourth time in history the act is being used, will want that full record.
And then I just had one other question. So Judge Walker has noted the difficult issues about the airplanes and stuff,
Right.
that sort of mess that was happening on Saturday. The TRO, the written TRO says nothing about that. It just says
Right.
enjoined from removal. And I know that there's a bit of a kerfuffle in district court about those oral directions, and the government's position is those did not bind it. I think your position is that they did. So do we have to, if we were to be concerned about the TRO, at least as applied to directing airline flights out of U.S. airspace, but people still in U.S. custody, do we have to resolve that question of whether the oral language he was using at the hearing was itself part of the TRO?
I don't think so, Your Honor, because I understood that the district court to be sort of having two orders. The primary one was about going forward. He wants this enjoined so that other, and the other part was, let's try and stop the harm from occurring. So let's turn the planes around. Now that people are in the Salvadoran prison, the judge recognizes that the first step would have to be, was the order violated? The government says it wasn't violated because the planes were out of U.S. airspace, and there's a whole contentious thing going on. So I think it's.
I thought they said they now agree that they were bound by the oral. I thought they said that they were only bound.
They're still pushing back on that as well. I think Judge Boasberg has been fairly clear that he thinks the oral order was just as binding. But I think the question really has not been resolved in the district court. Judge Boasberg is first very meticulously going to try and find the facts about whether his order was violated and only then decide if there's a remedy. But he's certainly not going to do anything before he finds the facts. And I think it would be premature for this court to get into it because we're talking about the government potentially deliberately violating a federal court's order. And so I think it would be best to allow Judge Boasberg to find those facts. Certainly the government, if he was to order them brought back, could come back up here. I can't imagine Judge Boasberg not staying that particular part of his hearing, of his order, if he ever got to that.
Mr. Gallant, just a question about the timing of us deciding this stay motion. I know the government wants us to do it quickly. Do you see sort of the fairness of us deciding it fast enough that if the Supreme Court wanted to reverse us, they would have an opportunity before the TRO runs out?
Your Honor, but leaving the TRO in place?
Well, I'm not saying whether you'd win or lose. So I know you got. I'm sort of asking you behind veil of ignorance.
So what I would say is, Your Honor,
I do think
obviously we would,
as long and as eloquently as you argued about your client's, right to be heard in court. I think maybe you would say the government, as a matter of fairness, ought to have a shot at the Supreme Court if they lose here.
if that were going to happen and you were going to rule for the government on this, then I would hope that your honors would give us time to seek a stay from the Supreme Court without allowing everyone to be put on a plane to El Salvador in the interim. But I would urge this court to allow the district court to just finish its ruling.
I mean, if we're
Yeah,
gonna rule for you,
go ahead.
do you see that do you see the benefit of us doing that very quickly so that the government can get to the Supreme Court fast enough?
You know, I will leave that to your honors, whether you think that's.
You don't have an objection to that?
I mean, we would prefer that you deny the stay request and send it back to the district court. And I don't think you need to rule quickly. I mean, I just want to leave with one point.
Real quickly, if we're gonna rule against you.
Right,
and
well,
real slowly
exactly.
If we're gonna rule for it.
Exactly. I just want to leave the court with one point. If the government is going to stand up on reply and admit that under Supreme Court precedent, people have to have the ability to contest, and that that's a matter of Supreme Court precedent in lunatic, the statute, and if you want to throw in due process as well and about the implementation, then it's inconceivable to me how they can say this is an intrusion on national security, because they themselves are saying, yes, at least that part of Judge Boasberg's order must stand. And so that certainly can stand until there's a preliminary injunction ruling. But I just don't see how the government can continue using this broad rhetoric about intrusions on national security if they're conceding that Judge Boasberg is right as at least our secondary claim that there must be process, even if he was not willing at this point to rule on whether the Alien Enemies Act can be used at all against a non-foreign government.
Thank you.
Thank you, Your Honors.
Mr. Ensign, why don't you take 5 minutes?
Your Honor, I'll be very brief, just two very quick points. I believe opposing counsel said expressly that this case could be brought in habeas. Under this court's decision in LeBeau, which I think I mispronounced earlier, that very clearly means that it must be brought in habeas. That is not in a distinguishable context. That was brought
It
by.
involves something that couldn't be brought under the APA at all, extradition. That's not this situation.
Your Honor, I think the same.
Extradition is its own body of law.
It does have its own, but it is the same context of a person using habeas or in that case, actually using it in a different court. But the fact that habeas was available to challenge a transfer to a foreign country meant that because habeas was available in habeas, it must be brought in habeas.
Before Munaf versus Green and Thursagian. And Munaf versus Green was also, I mean, the court recognized that there could be habeas and that it could apply to someone in foreign lands under held by a multinational force in the middle of a war, but American citizen would still have the right to bring a habeas, and then just said that you can't get this relief of protecting you against transfer to another government in habeas. That seems to be, and that did not involve, that was detention issues and transfer issues. It wasn't extradition, which is its own body of law and just sort of inapt in this context. And there's no APA option there. There's definitely an APA option here. That's the point of Munaf.
Your Honor, I disagree both that LeBeau and Munaf involved challenges to attempted transfers to foreign countries. In both cases, the court said, in LeBeau, the court said that has to be brought as habeas, and because it could not be brought as non-habeas. And in Munaf, the Supreme Court said that can be brought in habeas. That was the first question presented that the court resolved by answering in the affirmative. And then under LeBeau, that means that it must be brought.
Habeas is available to someone named Munaf in this foreign situation. I mean, talk about interfering with the conduct of a war, but that habeas is available to people in his situation. But it's not, he wasn't seeking a form of relief that habeas could provide, which by definition, he didn't fail on some sort of individual merits. He said, this relief of stopping a transfer to another government is not available under habeas.
Your Honor, I heard my opposing counsel say to you directly that this could have been brought as habeas. And so I think LeBeau means it has to be.
I think what he said was people could individually, if given notice and time, bring habeas. Well, does the government agree that they could bring a habeas class action as long as they did it in Texas? I mean, if the habeas class action is going to have to be wherever these people are held.
Your Honor, I'm not aware of specifically case law barring that. I believe opposing counsel
Does the government
reference.
have a position on habeas, the existence of habeas class actions?
Your Honor, I don't have a definitive position of the government. That was decided on an extremely accelerated timetable before we had an opportunity to file a brief, with any legal reasoning.
It's hard to figure out how you'd get past the class criteria because you're gonna have to have individualized showings, but if it's allowed, then I guess it's allowed. It seems a difficult question. Seems quite uncertain question.
I mean, Your Honor, plaintiffs clearly take the position that they can bring so, and that they effectively got such class relief even before their habeas claim was voluntarily dismissed, I believe.
And so I guess what I'm trying to figure out is, you're asking this course, you've agreed, I guess they say grudgingly, I'll let you decide your own adverb, but you have agreed that these folks are entitled to notice and due process.
Your Honor,
That's not a violation of the DECI.
Your Honor, we've agreed that challenges to individual determinations can be brought in habeas, that there's precedents that recognize that, including Ludecky, which allowed people to bring certain challenges in habeas. I think much of this exchange has,
Before they're removed?
in
Before, it certainly wasn't DECI.
in this case, this action was filed before they were removed and included habeas claims and obtained relief.
Are you agreeing that what they have a right to do is notice and an opportunity? Not going to be a long opportunity, I would assume not, but a reasonable opportunity, a fair opportunity to seek the type of review that's allowed under the AEA of whether you qualify under a proclamation terms. Do they have a right to do that before they're put on an airplane?
Your Honor, I think the answer that this court provided in IM is if you bring such a challenge in habeas before you're out of custody,
No,
that can be brought.
No, that's not my question. My question is, because the government's in complete control of when these people get put on airplanes or not. So my question is, if they're lucky enough to bring it, that's one thing. I'm not asking that question. I'm asking, does the government agree that they're entitled to notice that they are being removed based on their status as a member of Tren de Aragua under the AEA proclamation, the president's proclamation under the AEA, and an opportunity to challenge that before they are removed from the United States?
Your Honor, we don't agree to the notice point. We agree that if you bring habeas, that you can raise such challenges and that they can
I
be
don't know
heard.
how you can bring habeas if you don't have notice.
Well, Your Honor, 5 individuals did here.
So no, they anticipated it. They filed before there was even a proclamation. And so if we were to rule for you, it sounds to me like if we were to rule for you and vacate the TRO, the government considers itself fully within its rights to pack every member of this class, including the 5 named plaintiffs, onto an airplane before there's a chance, reasonable time to file habeas petitions. Is that correct?
Your Honor, I think as we've discussed right now, there's nothing preventing these 5 from filing
That's not
habeas
my
action.
question.
Right.
My question again is, if we were to grant the relief you request, would the government consider it necessary to allow time, notice, and time to file a habeas petition before removing people under the proclamation? Or would it, anyway, that's A, or B, is the government's position that it could immediately resume mass removals of these 5 named plaintiffs and the class members immediately? A or B? If you've got a C, you can tell me a C.
Your Honor, I think it's B, that we take the position the AEA does not require such notice, but that certainly in this period, these 5 plaintiffs could bring habeas claims right now and are electing not to do so. They could bring it in the correct court, and they've identified no obstacles to doing so.
There's a whole class before us. You haven't moved to vacate the class certification. I don't know why you keep talking about these 5 people. We've probably got hundreds of people before us, and I'm asking about those hundreds, including those 5. And as to them, I understand your answer is B, the second we vacate, if we were to do that, people are lined up and put on planes without notice or time to file for habeas. Even though the government agrees that decision, they have a right to have the decision made about whether they even qualify under the proclamation.
Your Honor, if the TROs dissolve, the government believes there would not be a limitation and that the statute does not require such notice.
Does the government have any obligation with a class certified to notify counsel as to where these individuals are that are being removed, and so they even know which jurisdiction to bring a habeas suit in?
Your Honor, I don't believe that plaintiffs have sought such relief. I don't think the district court has ordered it. And so
Sought notice. It's not notice. And it seems it's the government here that says you got to file habeas actions. The whole solution here is habeas actions. Let's all have habeas actions. So it would seem a bit rich for the government to say, but we're not going to tell you where they are or where you need to file or give you time to file at all.
well, Your Honor, they certainly know where their own clients are and they're refusing to file
They
in the proper
don't. They
court.
don't even know how many are in this class. You
As,
can talk about 5, they represent way more than 5. I don't understand why we're just talking about 5. That's a point of class action.
Your Honor, they could certainly file in habeas. They seem to care about their
They can't
form
file
more
in
than
habeas
the.
unless they go to the right jurisdiction,
I absolutely agree with that premise, Your Honor,
if
which
they
is why
don't
they
know
need to
where they
file
are,
in Texas.
and the government won't tell them.
They know where at least some of them are, and they're
That's known
they're
to everybody
affirmatively
else.
refusing to bring habeas in those jurisdictions.
And there's, they're not refusing, they've declined, they've made a choice not to, that's supported by an awful lot of precedent. But that's not the point. The point is well, you must know how many more people are in this class.
Your Honor, there is a declaration that provides the estimate. I believe it's the CERNA declaration, filed on Tuesday or so. I don't recall the specific numbers, but it is in the record.
Are we 100? I'm sorry, I looked at it.
My recollection is it's in around 300 or so.
300. Is every one of them in the same jurisdiction in Texas?
Your Honor, I don't know that question.
Okay. They don't either. Hard to file. The other thing I just wanted to clarify is, it seems like you're sort of both crossing over here. The written TRO doesn't say anything about bringing airplanes back. It just says that you shall not remove people that are within the class. But it was in his oral direction, which you say was not, unless I've misunderstood the position. My understanding from government's position in district court is that was not a binding order until it was reduced to writing. And so when you're asking us to vacate the TRO, are you asking us to vacate the written TRO, which is one that you say is legally operative?
That is what we are asking this court to stay or dissolve. But certainly, I think plaintiffs are taking the position that that incorporates more than what is it within the four
But you're
corners
not.
of its writing.
Right, but you're.
We take a contrary position, but jurisdiction in no way depends on the merits, as the Supreme Court has repeatedly explained.
Okay.
Um,
Right, you want to wind it up?
Yeah, very quickly, Your Honors. On the habeas point, you've heard that it could be brought in habeas. Labue means that it needs to be so. We've also heard from opposing counsel right now that they intend to bring evidence of individual cases. I think that's important for 2 reasons. It is in severe tension with commonality requirement of a class. They're now getting into very fact-bound characteristics that are inconsistent with class adjudication. And I think it just again underscores how much this is sounding in habeas. My particular circumstances warrant you not exercising custody over me is a classic habeas claim, and it should be brought as such.
Right, thank you.
Thank you, Your Honors.
Honorable Court now adjourned until Tuesday, April 1st at 1:30 a.m.